Welcome to Case by Case. This is a podcast brought to you by Calum Chain and Luke Zadkovich from ZFZ. How are you today, Calum?
Very good, Luke. How are you doing?
Good. Yeah, really good. A few things going on, but always good to jump on the pod and talk about a new case. I think this is a case that kind of traverses some issues, procedural issues that we haven't really touched on before, Calum.
Yeah, we've got a summary judgment application here, which is a new one for us. At least I think it's a new one for us in the 50 odd we've done so far. And some interesting issues around a couple of sale contracts here.
Yeah, well, look, I was looking at it from the perspective of, we have a first instance decision here from the commercial court in England, and the claimant didn't turn up. The claimant didn't turn up to its own summary judgment to defend a summary judgment application against it brought by the defendant applicant. Look, we'll get into the reasons for that in a minute, but you don't see that every day, that's for sure. Although we've certainly had I'm sure you have as well, but we've had our fair share of cases where, let's just say that for whatever reason on the other side, cases aren't either being pursued the way that they should be pursued or defended the way that they should be defended. And then you end up in situations like what happened here.
Yeah, 100%. And this one seems to have kind of fallen. It's not been perfectly handled, and it seems as though when you go into the facts, the claimant whose claim is under application for a summary judgment. To be clear, the defendant is applying to knock out the claim at a summary stage. And the claimant's claim obviously has some problems that are caused not necessarily by the claim itself, but rather by issues around time bar and limitation periods and things that are kind of unenforceable errors, if you like.
It looks that way. It definitely looks that way. So just a quick citation. We're talking about the Anron, A-N-R-O-N, Anron Bunkering and Glencore Energy case. This was handed down on the 14th of February, 2023. Citation 2023 EWHC 295 Comm. This is a decision handed down by Mr. Simon Colton, QC, sitting as a Deputy High Court Judge. And as we said, there was an appearance for the defendant applicant, so Glencore, and there was no appearance by the claimant respondent at this summary judgment hearing. And I think perhaps before we get into the summary judgment application itself, Calum, we probably should touch on the adjournment application that was made by the claimant prior to the day of hearing of the summary judgment. Pro se, it was made without representation.
Yeah.
So maybe if we just touch on that to begin with before getting into the meat of the case.
And I don't know, even before we start, it's worth just talking through the kind of background facts before we can come to them after.
Sure.
Yeah, let's start
either way.
So we've got the defendant's Glencore, and the claimant is Anron. Anron and Glencore enter into sale contracts for unleaded gasoline. Glencore is selling for delivery to Yemen. There are two contracts. There's the July contract and the November contract. The July contract is for 60,000 metric tons of unleaded gasoline, and the November contract is for two separate parcels of between 30 to 35,000 metric tons. The July contract was completed. The cargo was discharged. The price was paid, etc. Of the two parcels for the November contract, there was a part of the first installment was discharged, and the second installment was not discharged at all. It seemed as though there was some kind of arbitrage that Glencore took advantage of to basically say, we're not going to discharge the rest of the first installment, we're not going to discharge any of the second installment. And it was then the case that at some point there was a acceptance of Glencore's repudiation of the November contract. what happened next is there's this kind of balance of account period where advance payments have been made under both contracts of an amount of slightly over 50 million. And Glencore produced a statement of account that said, you have basically paid us everything that you owe, save for a few other entries. Glencore's statements, it seemed, basically said, we accept that we have been overpaid by about $2 million on the unleaded gasoline, but there are all these other payments that you haven't made to us that basically reduce that debt to zero. So you're not getting your $2 million back, and that's the end of it. Slightly more than 6 years later, there's a claim brought on a number of different grounds, which it really is for a return of that $2 million in the statement of account is kind of seen as an overpayment for the gasoline.
Exactly. So look, there were substantial payments made, obviously, and it looks to me, judging back and from what we know in the summary here, that Glencore were very careful to make sure that they were in funds for what was being discharged, and there came a point where they may be discharging more than they'd been paid or would be paid, and they pulled down the hatches and said we're not going to continue discharging, and sold it on to Vijaya, took the cargo elsewhere. And then, as you say, there's this discrepancy. I'm not sure if that's the right word, but there's this balanced debate around the 1.95 million odd, and whether that was washed out through other amounts that Anron owed to Glencore, or whether Glencore still owed that to Anron. And so Anron was claiming that amount on a couple of different bases. But before we get into that aspect of it, I just think it is worth touching on what has happened procedurally. So the claimant was represented by solicitors. The claim was brought by solicitors, and there then became an issue. We actually know quite a lot about the ins and outs of the claimant and their own solicitors, which is quite unusual. But we know that there was some kind of payment dispute. It looks like the claimant stopped paying their lawyers. Lawyers and the solicitors and or their counsel had concerns over the merits of the case and was raising that with the claimant itself. And it got to the point where the claimant solicitors and barristers said, we're not going to continue working anymore until you put us in funds and pay us. Quite a reasonable position, I'd say, to take, Calum.
I think we'd all say on this podcast that that's a very reasonable position to take.
Quite. So anyway, the solicitors on record then pull out. They're off record. In the meantime, during that process, I think when solicitors were still on record, Glencore had hit them with a request for further information and tried to get a little bit more information around how the claim is being put. Got some information in that respect. And then Glencore has brought this summary judgment application in lieu of putting on a defense, and just went straight to try and strike out the claim. So then the solicitors come off record for the claimant. The claimant's scratching around trying to find other solicitors right up close to the summary judgment hearing, and according to the claimant, is struggling to do so. The claimant then writes to the court directly, again, unusual but not unheard of, explaining its position, saying, we don't have solicitors on anymore. We're struggling to find new solicitors. We want to adjourn the summary judgment application. And this is made directly to the court. The court deals with it. The court asks for the defendant, who are represented, to respond. So Glencore responds, represented by highly esteemed counsel and a top solicitor firm, and they explain to the court, in the usual way, what are the parameters for dealing with an adjournment application, what are the issues to be looking at, and explain why, in their view, an adjournment should not be granted. The claimant itself, again, without representation, writes back to the court and dumps the court with all the communications, or at least a large amount of the communications between it and its solicitors and its attempts to find new solicitors. And in that process of dumping information, there's a host of inconsistencies and, the claimant saying one thing and then saying the next thing, and also just blows privilege on the merits advice that the claimant had received from its solicitors saying got a bad claim and this and that. So then the judge has to deal with it.
Yeah, exactly. And this isn't just a sort of slightly bad waiver of privilege. This is awful. There's an email in December 2022 in which Anron, the claimant, is informed that counsel has resigned from the case, saying that he does not wish to be further involved in a case he considers not to be of any merit. And the solicitor goes on, were I to instruct a new barrister at this late stage, I see little prospect that the barrister would disagree. He then continues, I've asked for monies on account on numerous occasions. I've wasted a ridiculous amount of time endlessly chasing for payment. So these messages really don't help the claimant at all, because firstly, he's telegraphed to the court and to the defendants that the claim is at the very least highly, highly shaky. And secondly, if you're going to get a adjournment from the court, which courts are pretty loath to give, particularly given the lead times for fixing dates nowadays.
7 months, I think the court says here.
Yeah, exactly. So the court is just not going to say, okay, well, we'll just wait 7 months. They're going to say, we've got the date now, let's do this thing. Unless there's some reason outside of your control that's really forcing you not to do it now. And looking at this, it's really just a litany of the claimant's own errors in the documents that the claimant is providing.
Yeah, and I think the court summed it up that the claimant appears to have been wanting to run this case and continue it to negotiate a settlement or get something out of it without having to pay for lawyers to do it. And yeah, it's classic. The solicitors haven't been paid. They had to come off record. New solicitors, when approached, have said, well, I'll look at it. I'll deal with it. I'll see what I can do. I think one of them said, no, it's too short outright. But another one said, okay, I might be able to look at this, but you got to put funds on account. And, again, the claimant wasn't willing to do that.
Yeah.
So you're not going to get a lot of sympathy from the court.
Sure enough, they do not get that sympathy. The court said that the burden lies on Anron to justify the adjournment, and then Anron did not satisfy the court that Anron is not responsible for its lack of legal representation. On the contrary, it appears to me more likely than not that Anron, having been advised that its claim was bound to fail, has been dragging its heels in the hope that it can achieve a negotiated resolution of these proceedings without the need to incur legal fees. So exactly as you say, Luke, the court takes a pretty dim view of all of this.
Absolutely. And look, I think it's worth emphasizing here in a broader sense that court deadlines are held pretty firmly. You've got to have good reason, particularly for a hearing. You've got to have good reason to seek an adjournment of them. And it's a completely different ballgame than arbitrations, or although even in arbitrations these days, if you have a hearing fixed, it's hard to move them as well. There has to be really cogent reasons for it. So then the court goes on to deal with the summary judgment application, has the hearing. A couple of points I thought to note at the outset of that. One, the court notes quite clearly that it's in the unusual position of having seen all this, what would have been privileged legal advice saying that the claim is worthless and whatever else, and then says, I find it irrelevant. I'm not going to rely on that or look at it. Well, not probably look at it, but not rely on it or consider it in coming to a view. I'll come to my own view, which, of course, but at the same time, it doesn't set a good tone or a good kind of, foundation for the judge to look at the case. You wouldn't want to be in a situation where the judge has already seen it, even if, in this case, Simon Colton KC is saying, I'm not paying attention to that when making this judgment. The other thing, I just reflecting back on the adjournment application, something I thought that was well handled in this judgment
if I can say that, was that the former solicitors who were accused of all sorts of negligence and other wrongdoings, but seemingly on the facts of the judgment hadn't done anything wrong. They weren't named at all in this judgment, and I thought that there was no reason to name them. But quite often you see these kind of things slipping in. You sent an email to name of this person, or you received an email from this person. And I thought in a situation where there seemed to be some quite heavy accusations of negligence that are pretty unfounded, I thought it was quite nice to see that the Simon Colton KC, sitting as a deputy, had decided not to kind of name anybody involved.
Yeah, I hadn't noted that, but now you say it, it's a good point.
Because I was looking for who it was.
Oh, good one. Yeah. I don't think they didn't say who any of the solicitors were, did they?
No, but
barristers.
You know from the front page, obviously, that it's Clyde's on for Glencore. And then Vencoffer.
I saw that.
Yeah,
I saw that. Yes. But I mean the subsequent solicitors that were approached or anything like that.
No one on the claimant side.
So, summary judgment applications. There's two kind of legal aspects here to touch on. One is what's the threshold, or what's a judge looking at, or the court looking at? What's the court looking at when dealing with the summary judgment application? I think that's one point just to touch on. And then the second one is the substantive legal issues that are being decided here, whether an implied term should be implied in these sale contracts or not, as the claimant has alleged.
And I don't know about you, Luke, but I thought that it was interesting just to kind of go back to first principles on when you get off the ground on a summary judgment application. And the case that was cited was Easy Air Limited against Opal Telecom. And the kind of passage, there's a reasonably long passage which is quoted in the judgment, in this judgment that we're talking about. But the kind of key bit there for me was Justice Lewison says in the Easy Air case, if the court is satisfied that it has before it all the evidence necessary for the proper determination of the question, and that the parties have had an adequate opportunity to address it in argument, it should grasp the nettle and decide it. And that kind of sets the tone for the court's view on this thing, which is basically if there's a legal threshold question and the court has all the evidence that it needs, then you can go ahead to summary judgment on that question, and the court should be, as they say here, grasping the nettle.
And that's what the court did. It went on to grasp the nettle. I suppose the alternative is if it is, this is what the authority says, if it is possible to show by evidence that although material in the form of documents or oral evidence that would put the documents in another light is not currently before the court, and such material is likely to exist and can be expected to be available at trial, it would be wrong to give summary judgment because there would be a real as opposed to a fanciful prospect of success. But it's not enough just to kind of speculate and say, well, look, something may come up during the trial that's going to change it. The way I think of this is it something that's going to turn on evidence, or is it something that's going to turn on law? It's not that strict, but if we're talking about a relatively straightforward legal point that's not going to need the full hammering of all the evidential points argued and the rest of it, and it can be dealt with simply, then get on with it. And that's what this case really turned out to be.
And then there's just another kind of neat aside in this judgment, which is the principles that apply where you have a uncontested hearing. Again, just one of these things that comes up every now and again that you see in cases, and it's always helpful to have the citation to hand if you're that sort of person. And there's a case called Herberdon Management against Cummings Power Generation, which says that participating party is under an obligation to present the case fairly. This is not the same as a duty of full and frank disclosure on without notice applications, but an obligation to present the facts and arguments fairly. So an interesting point there. If you're uncontested, then you have to be fair in your presentation of the case. It's not as much as going into the detail of full and frank disclosure, but you do have to be fair. And I thought, certainly from the judgment, that was the case here. Benjamin Coffer was counsel for Glencore, and he raises some actually pretty interesting arguments, and we can get into those later, Luke, on the sort of arguments that the claimant might be bringing in response to this application for summary judgment to say that the summary judgment application should not succeed. So he throws out those arguments to kind of say, if they were here, they might be arguing this, they might be arguing this, even though these points were not pleaded. He's kind of telling the court, like, this is where they might go.
Yeah, and it always goes a long way, doesn't it, with the court when you do that. And it's impressive sometimes to see how counsel does that. And you actually, have some obligation to do that to an extent when the other party's not there, different to an ex parte without notice application where you actually have a full and frank disclosure obligation, and so you need to go to some length to put the other side's case as well. But what's interesting about this is it's not just done in cases where the other side are not there. You also see this technique done when the other side are there. It's almost like getting in first. So in your opening, you may say, look, it may be set against me, or the other side may put this to you, but here's why they're wrong. And like, this is the argument they could make. And, you actually hear it at the time being made. Like, why are they making the other side's case out? And they said, and this is why it's wrong. Bang, bang, bang. and here there was also an out for the court, as you've alluded to there, in that these arguments weren't pleaded. So even if there was something to them, the court had the out to say, well, if I were to contemplate that argument or to continue, I'm not going to in this instance because they're not pleaded, right? As it turns out, the court was actually with the respondent on the arguments, but there's that saver as well.
Maybe it's a good time to move on to the arguments themselves, because to me, this was a pretty straightforward claim for money hadn't received. And when I first read through it, they were bringing all these different arguments about implied terms. There's an implied term that Glencore need to provide an SOA. There's an implied term the SOA needs to be accurate. And I was thinking, why is this not just being brought as a claim for money hadn't received? And then you check the dates and you realize that claim for money hadn't received is time barred. So all these other claims, exactly. So they're just trying to find a way to bring some other argument to recover their claim for money hadn't received. And I mean, to me, I actually thought that one of the arguments raised by Mr. Coffer for the defendant applicant, but raised kind of on behalf of the non-attending claimant, was a pretty good one, which was basically the argument here was that there was a complete failure of basis, so that money should be returned. And the argument that was identified by Mr. Coffer, again, he's presenting for the defendant, but he's raising this argument as one that the claimant might run against him. And he says that you would, in order for the failure of basis to arise, you would have to have the contract terminated, determined, or discharged first. And there's some support for that position at law in a couple of cases. There's some also support against it. But it seemed to me, just kind of thinking through it practically, that there is at least a decent argument that for a claim for a failure of basis should be on the basis of a contract which has fallen away somehow, whether it's been terminated or determined or otherwise discharged. And I say that because if you have a sale agreement and the sale, I agree, for example, Luke, I agree to sell you, I don't know, 10 bananas, and that I just don't. I agree to sell you these bananas. You agree to pay for them, and you pay for them, and I just don't give them to you. The deadline goes past, and I still haven't given them to you. As far as I'm concerned, I'm still under an obligation to give them to you at some point until the contract is kind of concluded, or you say, forget it, I'm never getting these bananas from you, Calum. I still have that obligation to give them to you at some point. And it's at the point where we say, okay, actually, this contract now falls away because you've completely failed to give me these bananas. I paid for them. Contract's over. Give me my money back. that to me is the kind of ordinary situation. So the difficulty for Glencore here was to identify that there was a point in time before the contracts were terminated where Glencore's failure of basis had happened. And again, the reason that Glencore here are arguing that they'd completely failed to perform under this contract at some earlier date is because the earlier Glencore can push that date, the higher the chances that it's time barred. So there's kind of an all-round agreement that Glencore didn't perform the contract. Glencore are trying to say we had not performed the contract at a very early stage, and Anron are trying to say, actually, you had not performed the contract at a much later stage, and that was the point at which our right to recover the money from you crystallized. So I thought it was interesting to see that point kind of kicked about.
Yeah, and I think the judge said here that in his view, it's not a requirement that the contract in question needs to be terminated in a sale of goods case before a claim for unjust enrichment can be brought. And he set out that the test is whether the state of affairs contemplated as the basis or reason for that payment had failed to materialize.
Yeah.
So it's a broader concept than termination. Now, in many cases, that will be a termination, right? That is an ending. That's a clear cutoff point, if you like, where the basis fails. But there can be other situations where that arises without a termination. And there are a couple of examples that were given. One is where there are defective goods that are delivered and the buyer cannot recover an advance payment or an installment unless and until it has decided to reject the goods. And then there's a second example given as well in the case of late delivery. If delivery remains a possibility under the contract, then it may not be possible to conclude that there is a failure of basis unless and until delivery ceases to be a possibility. And that may in reality only be when the contract is brought to an end. But in other circumstances, it may be concluded that the basis has failed to materialize, this failure to materialize kind of concept, even without the party terminating the contract. Yeah. So I tend to think that makes sense. I don't see the need for such a black and white rule on termination being a formal termination. I think there can almost be and this is not a phrase used in the judgment, but a termination of facts, like there's something factual arising that puts a punctuation, a full stop in the chain of events that then you can say, okay, there's the failure.
So here, for example, it seems as though there is this point in time where the goods that would have been given to Anron, the claimant, were delivered somewhere else to a third party. And that was before 6 years before the claim was filed. So in that situation, the judgment here is really saying from that point on, there was no possibility of this being performed. So there was the failure of basis. And I totally see that. And I think it maybe in some cases it depends on how specific the contract is. You know, how specific is the cargo that you're purchasing? Has that specific cargo actually completely gone? And I suspect it's probably a situation, as you say, Lucas, it doesn't have to be completely black and white. The majority of cases probably will require that termination, or probably will maybe not require the termination, but probably the point at which you can see this crystallized failure of basis will be at the same point in time as the contract is terminated or extinguished or determined. But in some cases, such as this one, there is that possibility that the contract just simply cannot be performed anymore. And once that date has passed, then you kind of crystallize your point in time at which your claim starts.
Yeah, exactly. And look, then the court went on to hold that, look, even if it's wrong on that point, that this failure to plead would have been enough for the defendant to succeed anyway. So there is this catch-all. I'm sure that's put in there. Well, I'm sure it's put in there for good reason, but also it hinders an appeal, makes it difficult to attack this on an appeal. And I don't know, maybe there is. I'm not convinced that point is super black and white. In different circumstances, and maybe if this went to trial and we had full facts and all the rest of it, maybe there is a legal point to discuss there and to argue on this termination issue. But in any event, in this case, I don't think it's going anywhere. And there's the catch-all on failure to plead. Then there's this other alternative argument. This is the second kind of point that counsel for Glencore submitted, that the statements of account that Glencore sent to Anron could be considered as an acknowledgement of a debt owed, and that acknowledgement would be sufficient to found the action and get around the limitation issues. Mr. Colton QC, sitting as a deputy judge, he found that it wasn't basically an acknowledgement of a debt owed. It was a document that showed credits and debits and claims, and basically set up a debate rather than something that is a clear acknowledgement of a debt, and so kind of dismiss that option, that argument that had been put up in a putative way by the defendant.
Yeah, and this is a kind of statutory claim almost in the section 29, subsection 5 of the Limitation Act 1980. It says effectively that you refresh that time period if someone acknowledges the debt, and they were saying basically the SOA refreshed the time period, to which the court said no, because the SOA didn't acknowledge that there was a net balance owing. It said it was clear from the SOA that there had been this overpayment of 1.95 million, but there wasn't an acknowledgement of any debt owed there because it was offset on Traffy's statement by other ancillary issues that are ancillary costs and payments that Glencore claimed had to be returned from Anron.
Exactly. So the claims were time barred.
Time barred and failed, and summary application was summary judgment was granted in favour of the defendant.
The claimant got itself in a complete mess on this one. So yeah, interesting. Always a few different points to arise on these kinds of cases. Calum, thank you everyone for listening in. We hope you've enjoyed today's episode. Please do like, subscribe, share, all that good stuff. And listen in again next week. We'll hopefully have another podcast for you on Thursdays as per usual. Good to chat, Calum.
Cheers, Luke. Cheers, everybody, for listening in.